Hi guys, welcome back to the channel. Welcome to the channel if it's your first time around here. So I'm going to give you some absolutely brilliant information today. I'm going to tell you and show you how you, yes, you, can get your seized property back from the police even when they don't want to give it to you. Yep, you heard me, even they don't want to. So the property we are talking about is mainly, we're going to talk about mobile phones and other video photographic equipment. So first things first, let's just cover the legislation that allows us to make an application to the magistrate's court for a possession order. So you will get a warrant effectively that you can go to the police station, let's go boom. This is a warrant for the possession of my property. You need to give it back to me now. And they have to give it back to you now. Unless, if they don't, they would be in contempt of court. Yes. Now, the police don't want to be found in contempt of court. Can't be having that, can we? It'd be front page papers everywhere. Anyway, so there's two pieces of legislation that are very, very similar to one another, which allows you to do this. So let's just paint a little bit of picture. Say there's you and a bunch of other lads. I don't know. Let's, for example, say one of them's Marty, the other one's Ryan Rampage, the other one's Audit in Yorkshire, the other one West Audit Reports, and let's say the last person is Exploring with Josh. Let's just say you went to Liverpool and you was making a video at an immigration hotel and the security made loads of lies up and you got arrested and they seized your phones. So straight away, once you get out, whether you're on bail, it doesn't matter. You can't make an application to get your phone back straight away. You have to give them reasonable time to be able to, say, download the footage off that phone. Reasonable time would normally be about, I'd say 28 days would be more than reasonable, what a court would agree with. Anyway, it's now been a couple of months. They've had more than enough time. So the first piece of legislation, I'm gonna put it on camera like here, out there, so you can see it. So the first piece of information is the Police and Criminal Evidence Act 1984, Chapter 60, Part 2, Section 22, which relates to seizure and retention of seized property. And it reads, Section 22, 1. Subject to subsection 4 below, anything which has been seized by a constable or taken away by a constable following a requirement made by virtue of section 19 or 20 of PACE, above may be retained so long as is necessary in all the circumstances. Part 2, important part. Without prejudice to the generality of subsection 1 above, anything seized for the purposes of a criminal investigation may be returned except as provided by subsection 4 below. Switch to subsection 4, which states, nothing may be returned for either of the purposes mentioned in subsection 2A, which is for use as evidence at a trial for an offence, or for forensic examination, or for investigation in connection with an offence, and anything may be returned in order to establish its lawful owner, where appropriate. 2A, above, if a photograph or copy would be sufficient in that purpose. So the police have seized your phone. All they need off of that phone is some video evidence, which you've recorded, which I have recorded. So they are not permitted to keep your phone until the end of the case, to the end of the court. When all they need to do is download a copy or photograph of an image or video, then they can give you the phone back. They are not allowed to retain that. They're not allowed to retain that. And the second part of law, which basically says essentially the very same thing, is the Police and Criminal Evidence Act 1984, Code B, which was revised in 2013. And it reads as follows. Subject, so this is, sorry, let me clarify for you. This is section 7.14 C, retention of goods. Subject to paragraph 7.15, anything seized in accordance with the above provisions may be retained only for as long as is necessary. It may be retained among other purposes. 1. For use as evidence at a trial of an offence, to facilitate the use of any investigation or proceedings of anything to which it is inextricably linked, for forensic examination or other investigation in connection with an offence, or 5, in order to establish its lawful owner, blah, blah. Basically, it says almost the same as the other law. But it also says that section 7.15, property shall not be retained under paragraph 7.14, 1, 2 or 3, if a copy or image would suffice. And there's a bunch of guidance notes with that as well that says stuff like, before making an application for the court, ask the police to give it you back. Just try, ask them to give it you back. If they don't, make the application and you will receive your items back. There is a court fee involved. So what you need to do is you need to download yourself one of these, which is a N244, a magistrate's N244 form. And this is an application notice to the court for an order. So you put on the defendant's name, which in my case is Merseyside Constabulary. I'll put it here for you again. And there's a few little things. So fill out your name. What order are you seeking? Well, I am seeking an order under section 1 of the Police Property Act 1997 in order to have my personal property returned. It says that I'm not attaching a copy of the court order. I'm going to allow the court to generate that for me. I'm requesting a physical hearing in person. They ask you how long you would like the court case to take. If you don't know, just leave it blank. That is what the guidance says. Then ask if any dates that you're not available. Ask you what level of judge you would require. You need a judge or a magistrate, it does not matter. Who to serve the notice upon, which is obviously the other party, in my case Merseyside Constabulary, and their address. And then on another page, the next page, you have to outline your case. So what your grounds are, what your evidence is to influence the judge's, magistrate's decision to side with yourself. So I'm gonna tell you what I put on mine. Mine states clearly. On the 6th of the 6th, 23, I was arrested on suspicion of a public order offence by Merseyside Police. On arrival at Wirral Custody Suite, I had 2 items seized from myself. One was a Samsung Galaxy S23 Ultra mobile phone. The second was an unbranded body camera with micro SD card inserted. At this stage, I informed the custody sergeant that without my mobile phone, I would be in difficulty getting home back to Leeds, as this was my only method of access to my finances and also my maps to find where I was. I had no idea where I was. In the police interview, I informed the officers that I had recorded the incident in full, and I provided the police officer with my PIN number to my phone so she could easily view that footage and she could see that I'm innocent of the offences I am accused of. A short while after the interview, I was spoken to by a sergeant in my cell who had informed me that due to myself informing him that I would be in difficulty getting home in a safe manner, let's call it, he has made the decision to keep me in custody overnight, so tomorrow morning when I am released, I will be able to be provided back with my mobile phone, as the police are currently, right now, in the process of downloading my mobile phone. So, but they didn't, because they are what they are. I got out tomorrow morning without a phone, so I've said to the court, I make my application in accordance with the following legislation, Section 22 of the Police and Criminal Evidence Act and 7.15 of Pace Code B. I also stated at the bottom that I am certain that the police have been able to make a copy of the relevant evidence and have sufficient time and have had sufficient time to do so. There's then a couple more questions. If you have any disabilities or anything like that, if you do, tell them why. If no, you just tick no. Then you have to fill out your statement of truth, you know, to declare that everything you have said is true and accurate to the best of your knowledge. Because if you provide any false information on a court application, you will be committing contempt of court, and that's not what we want to do, is it? We want to be winning, not getting in trouble. So that is it. It is really simple as that. Below it in the box, I'm going to give you any information that you need. So I'm going to give you the download links for your application notice that you need to submit to the court. I'm also going to give you a link to a guidance sheet that just helps you and tells you exactly what you need to fill in and what you need to do. I'm then going to put links to these 2 pieces of legislation which you will want to quote to the courts, and also may want to quote to the police, as to enable them to hopefully make the correct decision in just giving you your phone back without having to waste the court's time. But that is that. And yes, you have to pay a £226 court fee. You have to pay that fee at the same time that you submit your application to the court, and that pays for everything. That is the only time you have to pay a fee. That will cover your court hearing, any back and forwards, any mails, also the payment of service for the defendant, and it will pay for the court order itself. So yeah, it's one of them. It's 226 that I can't really afford, but who cares? It's going to get me my phone back. It is one of them. If anyone wants to chip in a few quid to the court fee, feel free. I'll put a little link below. Buy me a coffee link, or I don't know, whatever else I can muster up. But yeah, if any of you have any questions and you need some help in relation to getting your property back from the police, give me a shout. I'd be happy to help. I'd be extremely happy to help. I'll put an email link for you below if you need help. So that's it, guys. I hope I've covered that really well. I've made it pretty easy and simple to understand. It is not a difficult process. So yeah, if police have got your property and you want it back and they're saying no, take them to court. Oh, another thing as well, if you are in receipt of benefits, only certain benefits apply. I think like disability benefits, PIP, universal payments. Then if you get any of them, then you can ask for a reduction of fees. I'll put a link to that below as well. You have to do an application in paper or online, and then they'll make a decision on if you have to pay anything or nothing at all. But yeah, it's just us lot who bloody actually work. We get bummed by courts, by court fees as well. But again, it is what it is. Guys, I hope that's helped you. I hope it helps you in the future. Please share it with your friends if they need any help. And just remember, you got this from Marti B. Guys, as always, until the next one, stay safe, peace and respect.